let me today introduce you to a very, very special member today. So we are with us today is Ruchi Agnihotri, and Ruchi has a very rich experience in the legal background. So if any one of you who is a director already or who aspires to become a director and wants any tips, any understanding, any knowledge about how does the legal perspectives of the director's role apply, or what is it that you have to grab from those legal regulations for the role of you to become an effective director. Here we are with Ruchi, and she will be taking us through her experience of past 25 years. And thank you, Ruchi, for joining us, and a very warm welcome to you.
Thank you, Neha, for having me. Thank you, Mentor My Board, for thinking of me. And thank you for the very kind words. I think they're too kind. I hope I can somehow, make good the confidence that you have reposed in me. And I hope I can add some value to anyone that would have some queries. And, all I have is my experiences and what I have learned while working. And if that can help someone, I'd be very happy. But I think you've been just too kind.
You will definitely throw some very, very important pointers or lights which we will be capturing upon here, and super happy to have you and engage with you in this conversation. And yes, at Mentor My Board we have a lot of training programs, a lot of events, a lot of sessions, some curated learning programs for different types of directors. When I say types of directors, I mean there are promoter directors, there are independent directors, there are women directors, startups, so on and so forth, right? So for each one, when you are speaking today, we would love to hear your insights in terms of what have been the experiences that you have gathered through the years in this particular field, and also that you have been a key figure in the dispute resolution and the white collar crime litigations. So how is it that you see these areas evolving, or maybe the laws evolving in these areas, and especially in this digital age when it comes to cyber crimes, the cyber security part, which is very well taken up in the boardrooms today, and which is being spoken about. So how is it that you see those conversations going along, and what are those key figures in the dispute resolution mechanism that you have come across?
See, I was a lawyer at a time when things like white collar crimes was not known. I joined the profession at a time when people did not have any sense of what is possibly a white collar crime. We understood criminal matters as simple matters of, at best criminal breach of trust under the criminal jurisprudence of the country, or, basic cheating, fraud kind of things. The concept of white collar crimes as we understand it today, which is it's like become jargon now for us, right? Was not jargon. We didn't even know it's called white collar crimes. So
and because you mentioned it as a jargon, Ruchi, I'm sorry I'm interrupting, but it would be really good if you elaborate on what is a white collar crime as well,
so that's
for the
audience. So white collar crimes is where you use illegal means to basically defraud or, do a scam, as we call it in layman language, non-violent means. So you're not actually killing someone or actually doing anything through a non-violent mean. You are illegally benefiting or enriching either yourself or the entity on behalf of which you're doing this, and you are using illegal means of doing this, but they're non-violent means, and that's a white collar crime. White collar crimes could be different, very different. As there are cyber crimes now, as we all know that, because we are all victims of some cyber attempt, at least, of cyber crime almost on a daily basis. Yes, so there are multiple kinds of cyber crimes, which are identity theft, where you can have your credit card hacked, you can have people asking for your PIN or asking you to download a particular link, and basically they're cloning things out there. So it's a number of cyber crimes. But white collar crimes were there earlier also. So you had different things, like maybe you could fiddle with the valuation of an enterprise, right? Let's say there's a disinvestment of a government undertaking. And there are advisors that are appointed to value that enterprise,
Hmm.
right? When you're valuing it, you're putting it on auction. So the valuation is the most critical thing. Now,
Right.
any corruption, because in India we still understand corruption very, very limitedly. In India we understand corruption as only government employee centric. You know,
True.
what you call bribery, literally, or undue financial benefit, but to a government officer.
Yeah.
But with liberalization came multinational companies. Multinational companies are listed on New York Stock Exchange. Multinational companies are listed on London Stock Exchange. We had the US FCPA in existence for ever. The UK Bribery Act came, I think, around 2010. These have cross-border implications, right? So if I'm listed, if I'm a multinational entity that is listed, even if I'm an Indian entity which is multinational in that sense, and I'm listed on the NYSE or on the London Stock Exchange, I get covered by US FCPA and or UK Bribery Act, depending on where I'm listed. It doesn't matter that I am not falling foul of Indian laws if I am listed on on the New York Stock Exchange. So
Correct.
basically, to cut a long story short, I started doing white collar crimes, not knowing they were white collar crimes, around 2004-5, where there was a hotel Corporation of India disinvestment that came under the radar. That time, the Enforcement Directorate, which is so much in the news today, was not really the nodal body running all these things. It was more the CBI that was running it, and things like that. So from there started that journey, right? Satyam I did not personally do, but the firm that I was a partner in did Satyam. Satyam is when people understood that this is important, this is big.
True.
This is how things can actually be done through. I didn't personally do that, so I really don't know the facts.
In
the
fact,
facts.
only after Satyam there was the Companies Act, which transformed from
Exactly. So around
earlier one to
2009,
2013. Yes, they could actually
2008-9 is when this happened, and then there was a serious rethink on how the Companies Act works and what should be the liability of directors. So then we had 2013 Companies Act, which actually put in a concept of vicarious liability there.
Okay.
So key KMPs, key managerial personnel, and how they are responsible. So those that are in control or take decisions and are in management of the company, they would be liable. They would be liable if the company, because that whole ability to sort of distance yourself from that decision and to keep yourself away from that decision was diminished. Not just Satyam, we had the Commonwealth Games scam.
Yes.
We had the 2G scam. So I've done fallout.
Even the Chara Ghotala came somewhere around the same time.
Yeah. So
it did not affect the corporates.
So the 2G scam was big in the sense that you had all, for the first time they decided to auction spectrum. Honestly, I'll tell you, spectrum was given free. From 2003 to 2008, all the incumbent telecom operators were getting spectrum free.
Okay.
On a first come, first serve basis. For the first time, an auction mechanism was devised. And the 22 telecom circles in India, the All India license, the UASL as used to call it, was valued at 1658 crores. And people were supposed to be given on a first come, first serve basis. All that was done was 10:30 a.m. in the morning, a notification or a circular was issued, which said that first come, first serve will not mean date of application, but date of completing financial documents. So a particular 2-3 entities who were otherwise lower down in the priority list in terms of their date of applying, came right on top simply because they submitted their financial documents. So that started the process. But it started from the SFIO end. I was involved from the SFIO end. It was first the SFIO end because what came under the scanner first was round tripping. Round tripping came under the scanner first. So the only analysis that was being done was, is there any round tripping of funds? Because most of the entities that acquired the license had nothing else That is what the 2G judgment was all about. And
Hmm.
nothing else except for that license.
Okay.
So you got a license for 1658 crores, but you had a foreign telecom operator investing 6,000 to 7,000 crores in you, right? So the question was, was it right valued or undervalued?
Hmm. Interesting. True.
I shouldn't be saying this, but the Supreme Court failed to see that 2003 to 2008 it was given free.
It was given free.
So but
I
they
know.
only focused on the fact that something which the company had no other asset except that license had an equity infusion from a foreign telecom operator, which was close to say 6,000 to 7,000 crores. So therefore, what should have been the value, and has there been a deprivation has the national exchequer been deprived of funds that should have been given to it, and should the spectrum have been valued higher? One. Two, why was the concept of first come first serve changed 4 hours before the deadline?
True.
So that was really the focus of it. I was lucky that the operator that I was representing ultimately did not have a criminal prosecution, but a lot of people had that whole criminal prosecution, and ultimately no criminality was found.
Okay.
But by then, the landscape of the country had changed. Because the 2G judgment had very far-reaching implications for foreign investors. Because I know a lot of people came and took advice from us and asked us, because they wanted to actually see the bilateral investment treaty arbitration route. Because it's a foreign entity that is investing in the Indian, in the Indian landscape. So they wanted to see whether they can file, institute a bilateral investment treaty arbitration against the government of India, as so there were many things, but investor confidence was badly shaken up by this. Even also to some extent by the Commonwealth scam, though not to this large extent. 2G was big. It was big in terms of the impact it had on investor sentiment in the country in general, right? There was a lot of, so that is all of that. And then 2013 we have the Companies Act. Was a 2G judgment came in 2012.
Right.
2013 you have the Companies Act coming. That changed how corporates are viewing the G in governance. So we have ESG, but G became very important because suddenly they realized compliance and being corporate governance ethics. Satyam sort of started the process, set the ball rolling, and with what was happening in 2011-12 and with the culmination in the statutory change and the concept of vicarious liability, suddenly everyone was taking this very, very seriously.
True.
To be honest, till about 2015-16, the concept of independent directors and the focus on independent directors was not really there. It has come about in the last 2-3 years, where suddenly people are feeling the need that they must have somebody on their boards, apart from, of course, the mandatory statutory requirements and all of that. But even otherwise, there is a need to have independent directors who can apply their mind rather than independent directors who are just rubber stamps.
Namesake or the
just rubber stamps. So there are a lot of companies that are actually invested in good corporate governance ethics.
True.
You have a lot of that. Your question was, how do I bring my white collar crimes experience, or this is I've been on the other side. I've seen what happens. And then when you do the backtracking, because you have to do your due diligence, right?
True.
You have to do an assessment of liability cannot be done without a due diligence. You get a lot of hindsight knowledge.
Right.
Why did you do this? Why did you do that? So those are the kind of questions that make you realize what you shouldn't do. Also, because we were when I was in Amarchand Mangaldas and then later Shardul Amarchand Mangaldas, we were doing a lot of advisory to MNCs on. MNCs are dispute averse. They're conflict averse. So you would say, what is a dispute lawyer doing really with an MNC? But most of them want conflict avoidance advisory. They want you to review it and see that this is not going to fall foul, because they just don't want to get into a dispute scenario. So they want to. So that is also a dispute lawyer's job, right? So what you do is you're actually looking at a lot of that. Could this result in a shareholder dispute? Could this result in something from a disputes perspective?
Correct.
So these are the kind of things that you can bring as in corporate governance, really, because you know where this can lead up to.
True. Exactly.
Because you've seen the outcome.
The outcome of it.
Yeah.
Exactly. Very true. Very true. Ruchi, you also mentioned about the independent director's role and the need of good corporate governance, and that is how I want to understand from you that how important it is for transparency in the corporate boardrooms today, and how do you think institutions like Mentor My Board can promote those best practices for governance amongst its members, amongst the boards, so on and so forth.
See, I think you're already doing a lot in terms of the fact that you have that room, you have many other such programs. I know both Divya and you are extremely proactive in the kind of there is something that is always happening in terms of adding to the learning, adding to the networking. So I think Mentor My Board's on the right track. Maybe the only thing that possibly you could think of is I don't know, you may still be doing it, I may not be knowing it, is probably be in touch with like headhunters and recruiters, etc., who actually do board placements, so that you know who you can sort of, I mean, they know they have somebody to come to in that sense.
True.
Because that's one thing that I have seen, that last mile connectivity in terms of the uh, you have people,
the trained
are
people
there,
getting
you are
placed,
training
actually.
them, you are
Yeah.
giving them that, you're probably even absorbing how good their skill set or how average their skill set or where their skill set is. Everybody is not fit for everywhere.
Exactly. Yes.
Yeah, if you tell me to be on an audit committee, I'll be useless. I'm not
True.
a chartered accountant. I'm not a chartered accountant. I can't pick up the nitty-gritties of anything like that. Maybe I won't be good on a nomination remuneration committee as well, because I'm not an HR professional as well. But I may do really well on a risk management committee, right? I may do really well in general in picking up something or the other, which a very deeply finance person or a deep HR professional may not be able to pick up.
Even the stakeholders committee.
There's no one size fits all, right?
True.
So I everyone may have different skill sets, and when you are training them or interacting with them, you do pick up what skill sets they have. So if there is that interaction that is happening with people who are actually doing board placements, you could say, oh, if you're looking for somebody in this space, this person could be tried, right? So to that extent, you could actually help people get board placements. I know you don't guarantee board placements, etc., but you could actually help people very effectively in getting board placements. So insofar as your question on Mentor My Board and what further role could be played, this is how I see it. Independent directors, look, now that's a double-edged sword, right? Transparency, yes. Is any promoter-driven board, or say let's a family owned company, primarily listed or whatever, but still family owned to a large extent, how comfortable are they with the concept of independent directors, and how do they view independent directors? So it's a double-edged sword. Can an independent director really take all cudgels and stand with all these swords drawn out and say don't do this or don't do that? It's not. Let's be practical.
Correct.
Let's be practical, right? You have to also become a trusted friend and trusted advisor.
True. In fact, what I think is independent director's role is more so of a coach, of a mentor to the promoters than becoming, a person who is holding those swords.
Yeah. So when we are when a patient goes to a doctor or when a client comes to a lawyer, they already know what's goofed up, what's happened wrong, right? They just want to understand how they can mitigate it, one, and two, how they can prevent it going forward. Exactly. So rather than going crazy and sort of, sorry to use such pedestrian language, but to say that no, you can't do this, I will not allow this to happen and all, simply because you don't want your vicarious liability coming into play and you don't want to be jailed. It's more important that you sort of set out the risks possible. Right. But you have to be part of it has to be a cooperative process. True. So yes, you should not allow something which you can see. Firstly, can I pick up? in something. I was doing this corporate directors workshop with another, this, and somebody who was an ex-SEBI member or something. He was saying that you have to do this, you have to do this, you have to do this. So I told him, I said, I'm a lawyer. Even if I try, Neha, even if I have been given the agenda, even if I know what the board resolutions which are meant to be adopted in that board meeting are, I may not be able to pick up a lot of nitty-gritties. I could not have picked up Satyam even today, I'm telling you. I could not have picked. Hindsight is a great thing. Hindsight, you can pick up any damn thing.
Anything. Yeah.
But like for example, the National Stock Exchange thing. If somebody tells you this is a good software, you should adopt this software. These are the benefits of the software. This is the value of the software. How are you going to pick up anything? How are you going to, even if you ask all the right questions, you may still not be able to prevent a scam or a fraud.
That is true. That is for sure.
Because a financial person, an accounting person knows what is happening. A person who's reading an agenda 2 days before or a night before, if they're very diligent, maybe a week before, and comes there, may have certain valid questions that are arising, right? But you really can't, I don't think so. He disagreed with me heartily and he threw my question in the dustbin, literally speaking. But I just said, look, I don't think, even if I try my level best, that I can actually pick up everything. If the management is committed to committing a fraud, if the management is, suppose it's an NBFC. I've actually done a scheme many years ago. Those it was section 391 and 394 of the Companies Act. I think the new sections are 230 and 234, etc., which is mergers, acquisitions, arrangements with creditors, right? So there was an NBFC. It ran into financial heavy weather, and they wanted to get into arrangements with their unsecured creditors who were just normal middle class people who had invested money into the NBFC, right? And it was a hotly contested thing, because actually all those 500-600 people who used to actually come to court, to air their grievances, and their hard-earned money had gone down the drain. They didn't want to make an arrangement. They didn't want to make any arrangement. They wanted all their money back as they had invested, right? And as they expected. So NBFCs, for example, have a lot of things that are happening in terms of, they have a lot of money that they take from the public, right? Now, if tomorrow they want to actually engage in a fraud, how will I pick it up as an independent director?
That is where, Ruchi, what happens is you must understand the industry that you're getting into. You must understand the company that you are being an independent director on, doing your own due diligence.
Yeah, but there is a balance, is what I'm trying to say.
True.
You do your best, but you do it in a non-aggressive way, which may be a better result-oriented way, right?
100%.
You try and explain. You have to gain the trust of the management also, that you are on their side.
Exactly.
And at the same time, you need to do what you are assigned to do, which is try and ensure that good corporate governance ethics are in fact followed here. So you do your best. It's a balance, and it's a very fine, precarious balance. And I think because it's a service industry, right?
Right.
So lawyers are geared to offer solutions to their clients. So I think as a lawyer, you could probably help in that. But to actually think that you can be this watchdog who's going to pick everything up, not possible.
That's not
possible. If somebody is saying that, it's a wish list. And there, to answer a question that may come from the audience, I don't know if it will, then how do we make sure that we are protected if suppose there is a eventuality? Because there are exceptions carved out. There are n number of judgments, even by the Supreme Court, etc., which say that unless, it has to happen with your consent, your knowledge, your connivance. You have to actively know what is happening. You have to consent to it. Connivance is you have to actually have to collaborate in that process. And unless you have done all of that, you can't be somehow prosecuted. Of course, it's I know for a layman, it's very scary to be called by an investigative agency and to come and make a statement there and to say whatever. But yes, it doesn't mean that investigative agencies are going to go after you, even if you are very clearly saying, look, I didn't even know.
True.
I didn't know. I couldn't understand this. And I'm really sorry.
Yes, but at the same time, ignorance of law is not an excuse as well. So
It's not
be
ignorance of
prepared
law.
when
It's not
you,
ignorance of law, Neha. You have to be
yeah.
able to pick it up, right? Now,
Yes, so
you have to
being
be able to pick
prepared enough is much more better than bleeding in the war, is what we say, right? So if you are becoming an independent director, having that kind of understanding, knowledge, and at least understanding the basics about everything is essential. While you may not be able to kind of, share everything on each of the topics that are being discussed in the boardrooms, but still, if you can kind of, put your experience on the table at some point of time in some maybe the agendas that are being discussed, that is what is expected from an independent director, because they are aware that independent directors don't know each and everything, and that is why you have so many of them on the board, right? So
correct.
that it makes a right cultural
It's a
fit.
best efforts basis, is all I'm saying. And
Right.
according to me, an independent director's role is more of a balancing role.
Balancing.
And you have to do your best in terms of the obligation imposed upon you by the Companies Act.
True.
And you have to also gain the trust of the management
Trust of the
and advise them. Advise them.
advise them.
And to
Exactly. That is
protect
right.
yourself, if you feel really concerned with something that is being done, you put it on writing.
Exactly. True.
You put it
So
in writing. So there's a recorded objection or a recorded note that is available on an email or something. I tried. Basically.
perfect. Perfect. So you have your own safety nets, and when and where you use it is something that you must know as an independent director, or maybe as anyone on the board who is, there on the board. So you must know when and what to use and how to use it for
Yeah, I
your
don't see it as an
safety.
adversarial role. That's what I'm.
Exactly.
It's
Very
it's more like a trusted advisor role.
Very true, very true. And yes, just to mention here, Ruchi, we've already done somewhere around 10 to 12 placements in the last year.
Oh,
And
wonderful.
we have just kind of, started it from last year, and we are doing it now very frequently. So, yes, that is
Oh,
one
that's
part.
amazing. That's music, because I'm still not a director on any board. So that's music to
Right.
my ears.
So, very soon you will become one.
Fingers crossed. I've just decided to do this about a couple of months ago, as you well know. So I'm still trying to find those feet, my swimming legs, as they say.
Yes, true. So yes, Ruchi, with your deep experience into both the international and the domestic arbitrations, right? So, what do you think are those biggest misconceptions that people around have with regards to arbitration, or how can corporate leaders leverage it more effectively?
Look, now this is again, the problem is we have such amazing statutes in this country. We have great rules, we have great regulations, we have great everything. When it comes to practically applying everything, that's where we run into a lot of problems. Arbitration as a concept, I'll tell you, okay, let me contradistinguish it, and from there you decide how you want to play this out further and what.
Yeah.
International arbitrations, which I've done a fair amount of, run on very different principles.
Okay.
Mostly you have international entities involved, MNCs, etc. You have generally institutional arbitrations. It could be ICC, it could be SIAC, it could be LCIA. You pick up your institution. They have their set rules. You trigger it off. It's done seamlessly. You appoint your nominee arbitrator. They appoint their nominee arbitrator. Very rarely you get into a dispute on the nominee arbitrators, and the institution appoints the presiding arbitrator. Within a year, maximum year and a half, your arbitration's done and dusted.
Okay.
And I'm talking of $1 billion claims. I'm not talking of small amounts here, right? It's done and dusted. You don't even have an evidentiary hearing till the very end.
Okay.
Everything is generally done on a VC, and things are. Nowadays they have memorial style arbitrations, which is like your statement of claim goes with your list, with your witness statements, with your expert reports, and you start your background work much before you actually file your request for arbitration, etc., right? So you get the award. You are not going to really, if it's in English law governed arbitration, you're not going to get challenges to that arbitral award. Parties will abide by it. So it's a great way of sorting your matters, because yes, you pay a lot of money to your legal teams. and but then the person who wins also gets the legal costs back, right?
Exactly. Yeah.
And or if you're contesting parties and you've initiated the claim, the other party has initiated the counterclaim by around the time of the evidentiary hearing, and I've had 2 or 3 of those also. Parties know this is going which way or the other, so they do their assessments and an offer of settlement is made, and generally it is even settled. So sometimes you don't even need to actually go into that very expensive hearing process, which is, it is a batch of generally it is a batch of a few days or a week or maybe a month, depending on the complexity of the issues involved. It's all over, huh? You start with your opening arguments, you finish with your closing arguments in that one batch only, all
Perfect.
your cross examination. So that is amazing. That is arbitration at its idealistic best. How does it happen in India? Slightly differently. And honestly, towards the end of my stint with Samco and Amarchand Mangaldas, I was doing more of international arbitrations, institutional arbitrations. So I didn't realize, but in the past 2-3 years, I have been involved in domestic arbitrations and public sector domestic arbitrations.
So to continue with the same, while you're mentioning this, what are those future trends?
So I'm shocked that things don't work in an alternate dispute resolution space. So what can I tell a corporate director today? I can't tell the corporate director that if you have an arbitration clause in your contract and you actually have an arbitration where you have 3 retired judges as your arbitrators, that you are going to finish very fast. I'll give you an example. It was an arbitration where the award was in our favor. We got the award in 2012. I left Samco in 2016 December. The Section 34 is still pending in Delhi High Court.
Quite a long time.
And what can I say? So now you ask me what should I be telling? It totally depends on what kind of arbitration it is. It totally depends on the 2 contracting parties involved, right? It totally depends on the corporate intent of the contracting parties. If you're going to engineer the arbitration like a litigation, and if the idea is award aane do, फिर we will go to court, we will contest it, we will do all of that, and we will avoid doing that award, then arbitration is the same as filing a suit.
Oh.
For me, at least the way I see it. But yes, if you're really intending to take this forward, you want a speedy, efficacious thing, you're going to honor the arbitral award, or you're going to make an honest effort to settle this out and finish it off. The idea is to move on, get it off your balance sheet, get it off your contingent liability notes to accounts, etc., etc., etc. Then yes, arbitration is an amazing mechanism. So
wonderful. Thank you so much, Ruchi. It was really great conversing with you, and actually did not realize how this time went by, but then it was really good speaking to you, and we look forward to having a deep engagement with you.
Thank you for having me.